Hello friends, if you like my dictation, please like, subscribe and share. Get ready, start. When the parties themselves have allowed certain statements to be placed on the record as a part of their evidence, it is not open to them to urge later, either in the same court or in a court of appeal, that the evidence produced was inadmissible. Stop. To allow them to do so would indeed be permitting them both to approbate and reprobate. Stop para. It is therefore a trite principle of law in the realm of evidentiary value of a document, that once a part of contents of a document is admitted in evidence, the party bringing the same on record cannot be permitted to resile in respect of another part of the contents thereof, and contend that the said other part of the contents or something contained in the rest of the part of the document, had not been proved. Stop. The claimant herein had relied on the FIR bracket open exhibit 29 bracket close, which was produced by them in the evidence. Stop. The contents of the FIR was relied on and admitted to show the factum of taking place of the accident. Stop. Having relied on the contents of the said document bracket open exhibit 29 in respect of the occurrence of the accident part, and the said part having been admitted in evidence, it was not open in law to turn around to contend that the other part of the document, which recorded about the sitting of the deceased on the seat of the driver on the front of the rickshaw, was not correct. Stop. The whole of the contents of Exhibit 29 ought to have been accepted by the tribunal in evidence to deduce therefrom the facts stated therein as proved and established. Stop para. The rule of evidence does not permit the acceptance of the document for its contents partially only, by relying on one part of it and seeking to discard as untrue the other part thereof. Stop. Therefore, once the factum of the deceased sitting in the front of the rickshaw with the driver and falling down therefrom was stated in the contents of exhibit 29, and when the other part of the contents were admitted and relied on, the first mentioned part of the contents as above, was not required to be proved by formal modes of proof. Stop. As the part of the contents of the document was admitted, the other part of the content deemed to have been accepted. Stop. The claimants themselves have brought the document in question in evidence. Stop. In other words, the claimants were stopped from approbating and reprobating in respect of two parts of the contents of the same document brought in and admitted by them, by saying that one part was true and what was stated in other part was not. Stop para. Therefore, it has to be held that deceased Galla Bhai, Duda Bhai, Chavda was an illegal traveler in the rickshaw. Stop. He had seated by side the driver in the front of rickshaw, where there was no sitting capacity and sitting thereat was not permissible. Stop. The deceased travelled illegally in the rickshaw. Stop. There was a breach of terms and conditions of policy. Stop. For death of such a traveler passenger, the insurance company could not have been held liable in law to pay the compensation. Stop. The contention raised by the appellant company is upheld. Stop.